our hearing. It's 1 minute of 11. I did just see Council Devaney and I'm going to come up, so we'll give her a minute to come up. And I understand that the tour is complete. Did everyone enjoy it?
Not complete.
Kennedy?
We're not done yet, Joe. Cut it off. Now, Judge Andrew was a Civil War, John Andrew was a Civil War governor.
Yeah, thank you.
He used to have fights with Abraham Lincoln because he thought Abraham Lincoln was too soft on the slavery issue. You know what I do here when I'm bored? I Google people.
Thank God for Google.
Which is often. He's often bored.
Whose glasses are these? Marilyn? Here.
There's Council Devaney, so now we can begin. All right, I'm going to call this meeting to order. I want to start by welcoming everyone here. I want to introduce the councilors. From my left is Councilor DiPaolo, Councilor Kennedy, Councilor Duff, Councilor Marilyn Petito Devaney, and Councilor Juvenile. And I also want to welcome all the guests from Judge Rieger. Thank you for coming. And what everyone probably knows, Lauren Green, the Governor's Counsel. And I'm going to let the nominee, when you speak, introduce your family and friends as well. So the way this works is we'll have the witnesses testify first, then we'll hear from the nominee. And after that, we'll give the councilors a chance to pepper the nominee with any questions they want for as many hours as they want. So, Kevin, I don't know how you get to the top of the list again, but the first witness is Kevin Readington. So Kevin, you're up. You're right. You can sit down or stand up, but my thing is you probably want to stand up.
You can sit over here, you can sit over here.
Whatever you want to do.
Oh, all
All
right, all right, I'll remember this. Nice seeing you again.
Wait, we call you Honorable, your Honorable,
No, just,
Ferrera,
you can just call me Joe.
members of the council. Yes. Chief. It's my pleasure to be here, testify on Brian's behalf. Known each other for, I don't know, 20 years, maybe longer. Tried a couple of murders with each other, some high profile stuff, very emotional, wearing types of cases. And one thing about Brian that I recall is that no matter how emotional the case was or how complicated the case was or how stressful the case was, he always had a smile. He always had a smile. I have a smile right now, I can tell. And he's an incredible advocate, an incredible attorney. Jurors relate to him, unfortunately, by my count. They love Brian. But more importantly, he's the type of guy that, in my opinion, when there's evidence that cuts against the government, you know, called exculpatory evidence, he's the first guy that would contact you and give it up. He'd send you an email, give me a call, hold stuff in his office. Next time I'm there, I come by. And of course, he'd provide the evidence to me. So you have a guy who I know is an incredible family man. Family's here today. Did meet his son, who's in the DA's office. I met him before, daughter. He's just a person of integrity, skill, and ability. And I truly believe that he would make an incredible addition to the bench. I believe that there's not one attorney, one trial attorney that would walk into a courtroom. And the first thing we always say to the court officers is, who's the judge today? But when you hear who the judge is, you either go yes, or you're like, oh boy. And with Judge Brieger, I always smiled and said yes when I would come in the court. But honestly, I just think that Brian is an honorable person. He is an incredibly skilled trial attorney, good family man, great in his community, respected and loved by everybody. And I highly commend him to the bench and for your approval.
Well, thank you. It's always a pleasure to have you before us, Mr. Readington, and we're going to allow the councilors to ask you any questions, if that's okay.
Good.
Anyone have any questions for Mr. Readington?
I knew it.
Councilor Devaney.
Nice to see you.
Nice to see
It's
you.
rare that we have you here. That's quite a tribute to the nominee to have you testify. Tell me, how many years have you known this nominee?
I would say well over 20, probably
Wow,
closer to maybe 30, 25, 30. We don't want to date ourselves too much, but yeah, been
Wow.
at least 2 decades or 2.5.
so he can't even count how many cases he has, I know.
Right.
Is there any case that you remember in these years that you saw his experience, his qualifications
Oh, absolutely.
to be a judge?
Absolutely. You know, I think what's important, obviously, is for a judge to have the ability to remain impartial, to be objective, to be fair, and be courteous. I have seen, for example, we spent, I don't know, a month on Nantucket trying the Thomas Toolin murder case that was just very highly charged. Poor woman grew up on the island. Her mom and dad had businesses on the island. We were trying the case in the selectman's office. And Brian was just so nice, even to my client's mother and father. He would even greet him in the morning when he'd come in that little room, the selectman's office. So I think that's important. The cases that we've had, as I said, he's a very honorable person as far as exculpatory evidence, giving up the evidence, providing the discovery. I know not, at least on 2 occasions, I've had to call Brian embarrassed and say, hey, I misplaced this, I misplaced the file, can you replicate it? And he'd make copies and get it right over to me. So I think he's got the personality. I think I've seen him under stress. He's never lost that smile. And I'm sure that he'd maintain that on the bench as well.
Thank you. Well, your testimony means a lot to me. Thank you for coming. I
Thank
really
you.
appreciate
Nice to see
it.
you again.
Nice seeing you.
Anyone else? Thank you very much, sir.
Thank you.
Good to see you, Kevin. Next, we're going to hear from Michael Barrows.
Thank you, Councilman
Welcome.
Ferrera. Thank you,
Thank you.
council members. Good morning. My name is Michael Barrows, and I'm honored to come before you today to talk about my friend Brian Glenny. I met Brian back in 1988. We were both working for the Cape and Islands District Attorney's Office. Brian was a young district court ADA. I was the IT guy in the office. One day, Brian had an issue with his computer. He called me over. I went down and fixed his computer. After I fixed his computer, we just started chit-chatting. And it only lasted a few minutes. But I remember leaving his office and thinking, what a really nice person he was. You know? He made an impression on me. I was new in the office at that time. I didn't know too many people in the office at that time. But I think Brian recognized that and wanted to make me feel comfortable. After that, I would see Brian from time to time in the office. We would talk sports, we talk music. We really started to get a friendship to get going here. 33 years later, I see Brian almost every single day. I talk to him almost every single day, and our friendship has really grown. Over the years, we've been to many Patriot football games together. We've run in the Falmouth Road Race more than 20 times. We've played on the same softball team. We played on the same flag football team, and we've really spent a lot of time inside and outside of the office. Our families have gotten together socially. We've gone out to dinner. We've watched sporting events, and I've watched Heather and Andy grow up. Andy now an assistant district attorney. Heather going for her doctorate degree. And I truly feel that Brian's family is an extension of my family. I truly do. Brian is probably one of the most intelligent people I know. He has this innate ability to analyze a problem, then come up with a solution very, very quickly. Brian is a workaholic. I'd say 90% of the time, his car is the last car in the office parking lot. Brian is quick-witted. It's very difficult to get something over on Brian. Brian is just a likable person. People gravitate towards him. And he just has this unique ability to make people feel comfortable and welcoming. For years, I think probably 30 years, Brian has run the Office Secret Santa, and he encourages everyone to participate. Every day in the lunchroom, we have trivia, and Brian organizes that and encourages everybody to participate in that. And I call Brian the glue that keeps us together. Brian is a very honest person, a very likable person, as I mentioned. In all the years that I have known Brian, I have never heard him speak or make a derogatory comment against someone's race, gender, or ethnicity. Never. That's not him. He treats everyone with the same respect and dignity. Over the years, I've gone to Brian seeking advice, and his advice has always been solid and well thought out. And I trust him. I've had good times and I've had bad times. And the only constant here, Brian has always been there. I needed him. Even when he was caring for Susan, his wife, when she was very, very sick, if I needed Brian, he was there. I feel extremely fortunate to call Brian one of my best friends. Thank you.
Thank you. That's very nice. Kind of a little somber, you know, I'm not sure. He's not going for sainthood or anything like that. Well, so there must be some funny stories you have, I'm sure.
Well, there are a few funny stories at the Patriots games. There's another ongoing funny story going on right now where my daughter's boyfriend, who I have a less than adequate relationship with.
I don't like him either. Yeah, I'm with you. I have 3 daughters, yeah.
It seems Brian and I have met him, and we've given a ride back from Boston a couple of times, and it seems that Brian has a better relationship with my daughter's boyfriend than I do. There was one instance when we were coming back from Boston, and we picked up Darius, and again, our relationship is not the greatest, so on the ride home, Brian and Darius had this great conversation. I maybe said 3 or 4 words. So as we get back,
Was it shut up, Brian?
as we get back to the commuter parking lots, Brian gets out of the front seat of the car, passenger side, and looks at me. We'll see you later. Okay, see you later, Brian. Darius, why don't you get up in the front seat with Mr. Barrows? I'm sure you guys have a lot to talk about. And I'll never forget the stare I gave Brian. If my eyes could spit fire, they would have. But there's a lot of stories. He's just a great person. I could sit here in front of you all today and tell you how much of a great person and the impact he's made in my life as well as my family's life.
That's terrific. Great testimony. Anyone have any questions for Mr. Barrows? Council Devaney?
Is there anything that you can look at one particular case that you were so impressed because it was a very complicated case and how he handled it? Is there one that comes to mind?
Well, actually, there was a project that Mr. Glenny and I, O'Brien and I, were tasked with a few years back. We were tasked with identifying all drug cases that a particular chemist worked on in our office. Now, you know, the way I looked at it, it was a monumental task because you'd have to look at each file, identify that file, who did the cert on that file. So, you know, I was trying to think, you know, how are we going to do this? Well, Brian rolls in, figures out exactly, we're going to create spreadsheets, we're going to go through individually, we're going to go through it individually, we're going to identify it, we're going to need projectors up here, laptops up here, and have this all figured out. And I remember looking at him going, how did you figure this all out? I haven't even got my jacket off. And he's had this all figured out. And for 3 months, 9 to 10 hours a day, we identified all those cases. And I have to say, Brian attacked the last case with the same vigor and intensity that he did with the first case.
Thank you.
Thank you very much. Appreciate
Thank
it.
you.
Thank you very much for your testimony, sir.
Thank you. Oh.
And lastly, although she was not on the witness list that I prepared, I guess Council Vanny thought it'd be okay for Heather Glenny to testify. So I approve of that. If you'd like to speak, you're welcome to speak.
Great, thank you. Hi, good morning. I'm Heather,
Good
Brian's daughter. I've lived with my dad for several years, just the two of us, as sort of a silver lining privilege that few adult children get to experience. That added to being a PhD student, studying literature, and also my dad's #1 fan, means I could wax poetic about his qualifications for this position, like Mike said, for weeks and weeks and weeks. But I'll keep it to 2 short anecdotes that I think are representative. So story 1, I like telling the joke that my dad got me into Stanford. Now, it sounds like that means he paid off somebody, pulled some strings, got me on the water polo team, something like that. But that couldn't be farther from the truth, or more out of character for my dad. So no, I say that because I wrote my application essay about my dad, specifically about his love of puns. He takes the dad joke to a whole new level, as everyone in his office can also attest. Every conversation, especially the ones when I need some cheering up, are sprinkled with puns, homonyms, allusions, riddles. And as much as this led to truly uncountable eye rolls as a teenager, I realized even then that these jokes were indicative of something much more meaningful about who my dad is. It's his careful attention to language that makes these rapid and incessant puns possible. It's his deep conviction that context is everything. He looks at words from every angle, with every shade and nuance they could have, how the same word can mean totally different things to different people in different places. And that's the same thing with the law, right? The law isn't just words, it's words in context, it's people in context. And he carries this careful attention to language, to the minutest details, into how he interacts with victims, witnesses, defendants, colleagues, opposing counsel, when I've seen this, right? With everyone, my friends, me, my boyfriends. Story 2. When I was little, someone broke into our house while we were all sleeping. My mom heard the noise, and like every movie scene ever, my dad went down to see if anything or anyone was there. There was. My dad, without violence, without anger, told the intruder, a young man struggling with drug addiction, to sit down. They had a conversation. My dad talked him honestly and calmly through what was going to happen next as he called the police and explained why it would be in his best interest to cooperate, not to panic, but to listen. And he did. The police arrived and the courts took it from there. And so what these 2 very, very small stories tell me is that whether cracking puns to make me smile, or sometimes just to make me really think about what I'm saying, or dealing with much more serious situations, my dad has always exuded and modeled a measured calm that is attentive, passionate, honest, and reasoned. It's a way of being that shows he is not only fiercely intelligent, but abundantly qualified to listen, to consider, and to act in a justice system that so desperately needs that kind of care. So thank you for the honor of speaking on his behalf today in front of you all, and I look forward to answering any questions.
Thank you, Heather. That was very nice. Anyone have any questions for Ms. Heather? Council Devaney?
Nice to see you again. It was such a pleasure meeting you. Your father's not too proud of you, you know that. And it is mutual. If you could give me one adjective to describe your dad, what would it be?
It's a tough question.
I know you have more.
You're the English
Yeah.
major. You
I
have a lot
know,
of
well,
work.
there's too many words. I think the first word that comes to mind is loyal.
Yeah,
To me, to his friends, to his
Great.
work. Yeah.
great. And I know that you went through a tragedy and how bad that was losing your mom, and your dad took over those 2 roles. And I understand his grief. I know mine, 21 years. But I know what it meant to you too, because my youngest daughter used to go to the cemetery every day and put cards. It was over a year, so I know. So I'm sorry, but you have a wonderful dad that has taken over. So now, what do you, did you always think my dad could be a judge? Did you ever feel that? You must have along the way.
Well, actually, my mom used to mention it a lot. Sort of like, Brian, you'd be such a great judge. Oh, you know, but he was always, like Mike was saying, so dedicated to the work in front of him and to the case in front of him, that it just took longer. But I always, I mean, of course, because my mom said it, I was like, yeah, of course. But yeah, after he said that he was applying or writing his application, immediately I was just like, oh, duh, you know, like you'd be the best.
Yeah.
And I, yeah, was just so excited.
Well, thank you for being a witness, and I really enjoyed meeting you and getting to know you.
Thank you.
Thank you.
Thank you, Heather. All right, next we're going to hear from the nominee himself and tell us, you would like to introduce your guest first, and then tell us why you think we should vote for you.
Well, thank you. That was with me. I want to thank Kevin, Mike, and Heather, but with me also is my son, Andrew. Michael Keith, the district attorney. Peter Lloyd, an attorney down on the Cape. Don Carpenter, an ex-judge. Sharon Tebow, the second assistant district attorney in our office. And I really want to thank them for showing up and being here for me today. I'd like to thank Governor Baker and Lieutenant Governor Polito for nominating me. I'd also like to thank the governor's chief legal counsel, Bob Ross, and executive director, Lauren Green-Petrino, for the help and advice that they have provided me during this process. I'd like to thank the Judicial Nominating Committee for passing my name along to the governor. And I'd like to express my deep gratitude to my witnesses who appear here today after taking time from their very busy schedules. Now, what can you say about Kevin Readington? And Kevin and I have done 2 murder trials together, and he was and is the consummate professional and is unquestionably one of the best trial attorneys I've had the pleasure of watching ply his trade. I've learned so much from the time that I've done cases with Kevin Readington. Now, I've known Mike Barrows for over 30 years before he married his wife, Nancy. Nancy used to be my victim witness assistant when I was doing the child abuse cases. And we used to always joke about the time we'd have spent together overseas when we had cases on Nantucket or Martha's Vineyard. After my wife died in March of 2017, we had a winter storm that knocked down portions of my fence. And there was Mike with his post digger to help me replace that fallen fence. And I can't tell you what that means to me, to a person, you know, who was just in a state of grief at that time, to see that there's somebody out there that cares enough to be able to just almost on a drop of a dime show up and help you with little things like fixing your fence, which meant so much. He's been a true and valued friend for over the 30 years that I've known him. He's not a lawyer. He probably understands this process less well than I do. And he didn't hesitate a second when I asked him to speak on my behalf. Even after I told him there would be up to 8 counselors who could ask him just about anything. I did tell him to feel free to embellish a little bit if you want. But there is one little bit of a tragedy with Mike, I must mention. Every Christmas party at the office, we would always Google Mike's name from the time he was at Bridgewater State University College when he was there, because he was the outdoor high jump record holder.
Oh.
Unfortunately, just this year, that record was broken, and it's very sad. And Mike talks about when we ran the Falmouth road races, and I've got to tell you, Mike was an athlete. You know, he could, I knew at any moment he could have just left me in the dust and run that road race, but he always stayed with me, you know, slowing his pace down to accommodate my pace to finish that race. And it's, again, just to show what a friend that he is. And I thank him for being here today. And of course, my daughter, Heather. Now, when my first hearing date was changed from Wednesday the 7th to Thursday the 8th, I have 2 children, as I mentioned. Andrew's my son. That made it easy for me to decide which of my 2 children would be able to speak, because Andrew, who's recently married, was going out to Minnesota to visit his in-laws. So he couldn't have been here on that date. Well, as it turned out, we got continued until today, and Andrew is back and he could have been here. But that's when I put in the list of witnesses and Heather was on it. So that's how I chose Heather, not over Andrew, but because she was available at the time that I handed in the list of witnesses. And Andrew was an assistant district attorney in Suffolk County, and Heather seeking her doctorate in English at the University of Chicago. Heather got her undergraduate degree at Stanford, her master's degree at Georgetown. The mother would be so happy to see how they turned out. I'd also like to thank my bosses. First, District Attorney Philip Rollins, who hired me. Don Carpenter, who's here, who was involved in that decision. I don't know how we got that by him. And District Attorney Michael O'Keefe, who's been my boss pretty much for the majority of the time that I've been in the office. I've had the honor of working for the Cape and Islands District Attorney's Office for 34 years, 1987 through now. Mike constantly reminds me, and all of our district attorneys, that it's our job to distinguish between real evil and natural human frailty. Now, this should be manifested in both our charging decisions and sentencing recommendations. I truly appreciate the faith that they all had in me in giving me the discretion to make charging decisions and sentencing recommendations. It's made me much more of an empathetic lawyer. Now, a little background about me. I grew up in Lunenburg, a small town in north central Massachusetts, 19 miles north of the big city, Worcester. I attended Lunenburg High School, graduated in 1978. My parents lived in the same house on Turkey Hill Road in Lunenburg from 1960 until their deaths in 1996 and 2016. My older brother's daughter now lives in that house. My father was a mechanic and served in World War II. My mother was a proud homemaker and worked at the General Electric factory in Fitchburg during the war. Together they raised myself and my two brothers. It came as a surprise to everyone here. I'm a middle child. My older brother Scott became the fire chief in my hometown of Lunenburg until his retirement. I was the first in my family to go to college and the first to go to law school. My younger brother Keith followed in my footsteps and is currently a practicing attorney in Worcester County. I graduated from Clark University in Worcester in 1982 and West New England College School of Law, I believe that's now university, in Springfield in 1985. While in law school as part of the work-study program, I worked at the law library where I learned the various research materials that were available before computers at Lexis or Westlaw, which of course were just around the corner. I was able to get a job as part of that same program with the United States Attorney's Office in Springfield. But the most important thing that happened to me during my law school years was meeting my future wife, Susan Jane Merritt. We were together for 34 years. My wife, who was from Connecticut, and I agreed to first take the Massachusetts bar, and then hopefully if we passed, take the Connecticut bar the next year, because we really didn't know where we were going to end up or where we'd be working. We took the Mass bar, and while awaiting results, we headed again to the big city of Worcester to find jobs. Susan was able to find a job with the firm of Readington, and I got a job with the law offices of Howard Potash, a single practitioner with a busy practice that gave me experience in civil discovery answers, requests for production of documents, and real estate rundowns at the Worcester Registry of Deeds. After taking the bar exam, I had sent letters seeking employment to every district attorney's office in the state. The Cape and Islands sent a polite letter back saying that they would keep my letter and resume on file and call me back if they had an opening. Well, apparently they did, because they did call me back when they had an opening with an invitation to interview about a year later. They offered me a job, and Susan and I packed up and moved off to Cape Cod. Susan got a job on the Cape with the firm of Murphy & Murphy in Hyannis, and we were married on September 23rd, 1989. 2 years later, in 1991, along came Andrew, and 3 years after that was Heather. Our household grew to include various times 2 cats, 3 dogs, and a hamster, all rescue animals. In the fall of 1996, when my wife was 36, she was diagnosed with breast cancer. This was the same month that my father died. He was 69. Chemotherapy and surgery followed, and she was declared cancer-free, clear margin. Then in the fall of 2013, when she was 53, there was a recurrence of the breast cancer. More chemo followed, and again, clear margins were found, and she was declared cancer-free again. In September of 2016, Susan was diagnosed with pancreatic cancer. Radiation chemotherapy were applied. In October of 2016, my mother died at the age of 86, and on March 22nd, 2017, Susan died. She was 56. Now, I was in the district court for 2 years before being promoted to Superior Court. I prosecuted cases ranging from possession of short lobsters from the town of Gosnell, Cuttyhunk in the county of Dukes County, to homicides from all over the Cape, including Provincetown. I've tried over 20 murder cases. Of my last 19 trials, 15 were murder cases. But the cases I hope will define my time at the Cape and Islands District Attorney's Office would be the child abuse cases. The majority of the cases I've handled in the office have been child abuse cases. When I started, no one wanted to do the child abuse cases. No one wanted to investigate them. No one wanted to prosecute them. We were able to put together a team that consisted of 2 state police detectives, a victim witness assistant, and myself. We took different attitude about those cases. We got to know the DSS, as it was called then, workers. We spent time with the victims and their families. And as we began to do more and more of these cases, we decided that the individual towns should have their own detectives do the investigation of these cases. So we brought them into that group. And we had meetings, so the town detectives didn't feel like they were alone in doing the cases, because I found that in a lot of the towns, the detectives that were doing the cases felt that somehow that they'd drawn the short straw. So we had all of the detectives come and meet together so they could see they weren't the only ones that were doing these cases, that we could operate as a team, as it were. They had my home phone number. This was before cell phones, and they could call me at any time, and they did. From this, we have the CARE team. The Child Abuse Response Effort grew into the SANE, Sexual Abuse Intervention Network, and evolved into the Children's Cove, our Child Advocacy Center. Children's Cove is a cooperative in joining of Barnstable County, the Department of Children and Families, the Department of Mental Health, Cape Cod Hospital, and the Cape and Islands DA's office. The goal is not just to prosecute, but to assist and treat the victims and families of these terrible crimes. I've reviewed every DCF referral that's made to our office. This has increased every year. There's been changes in DCF and what cases are being referred now. In 2015, there were 82 referrals. As of 2020, there were 270. So the number has gone up every single year. As of June 6th of this year, we've already had 111 referrals. I review every case to consider if we should send it to be reviewed for a sexually dangerous person civil commitment. I did the first 3 SDP cases in the office when we were all just learning what it meant to have civil cases with criminal rules. I've applied the standard of whether as a result of a mental abnormality or personality disorder, the individual is currently unable to control his or her sexual impulses in over 300 cases that I've reviewed. And less than a quarter of all those cases I reviewed were sent off for our expert to be reviewed. And even less than that, do we actually file a civil suit that results in a case in court. I have tried 4 Superior Court cases that were the result of not guilty by reason of insanity. In 3 of those, that finding was uncontested. We agreed with the defense counsel that that was the just result. I represented the Commonwealth in the civil matter of Milo versus Taunton State Hospital in Commonwealth of Massachusetts, which was in the Fall River Superior Court in 2000. Mr. Milo had been found not guilty by reason of insanity in 1990 for the 1989 setting of a fire that killed his wife and 2 children, aged 12 and 19. 12 and 9, I'm sorry. And he was about to be released from Bridgewater State Hospital. So the officer thought that we should probably contest that and put the hospital to the test of actually establishing why it was that they wanted to release Mr. Milo and have that all on the record. So we did do that, and that was from Judge Garsh. I've tried hundreds of cases in both the district and superior courts. I have tried over 90 cases in the Superior Court. I've been the chair of the Cape and Islands Child Fatality Review Team since its inception in 2000. As to my civil experience, I don't have a lot, I admit that, but what I do have, I suggest, is significant. In 1990, the Barnstable County Sheriff's Office had let its insurance lapse. There was an allegation of a slip and fall at the House of Correction gym. By statute, there's no insurance. If there's no insurance, the DA's office represents the county. So we ended up representing Barnstable County. And I guess Don was involved in this decision because of my extensive civil practice in that 1 year before I joined the office that I should do that case. So we were in a place much like the insurance company, but there was no insurance, so there was no money to give out. This is just at the same time they changed civil rules and the civil tracking orders and the civil time standards. That suit was originally filed in Middlesex Superior Court. We were able to get that case moved to Barnstable County on a change of venue. We engaged in the typical pretrial civil discovery, interrogatories, requests for production of documents. There were no depositions in that case. However, I have done depositions in criminal cases when witnesses weren't going to be available for trial. The case was marked up for trial and we appeared ready for trial. The plaintiff and his lawyer didn't show up and we obtained a default judgment. I volunteered to be the Cape and Islands representative during the Annie Dukin drug lab incident because I didn't do a lot of drug cases in my career. And I felt that I wouldn't be bringing any bias with me concerning the drug cases. I wouldn't feel like, oh, I remember that case, that person was a bad person or something like that. I would be completely impartial. Mike and I, as he explained, I don't think I need to go into it, went through all of the cases, to decide which ones we could save, which ones we couldn't save. And right at the same time that the Sonia Farak situation was developing, that was the time that my wife died. So I had to stop and hand the cases over to Mike Donovan from our office. I'd like to thank the Executive Council for having this hearing, and I look forward to any questions the councils may have. Thank you.
Thank you. First, let me welcome the DA, of course. Always a pleasure, sir. And thank you for your letter, which will be read into the file as well. I also did receive some letters from other people that will become part of the file, from William Robinson, from Bill Burke. I have a letter from Judge Rufo. I have a letter from the Clerk of Courts in Superior Court in Nantucket, Mary Elizabeth Adams, and all of those will be coming part of your file as well, sir. Mr. DA, do you want to say anything?
I'm just here to support my guy with me for 30 years.
Thank you.
Done a tremendous job as prosecutor. And I know that great.
Thank you very much. Council Jubenville, did you want to say something?
No.
Oh, okay, I'm sorry. Judge, did you want to say anything, or the court officer? I'm not sure.
But I've heard all of I
Thank you. Well, thank you for coming. Thank you, sir, as well. All right, we will now let the councilors ask you some questions, and we'll start, am I right, with Councilor Jubenville?
Thank you, Mr. Chairman. Good morning. So I have this book here called Excellent Judges by Edward F. Hennessy. Do you remember Judge Hennessy?
I can't say I do.
He was the chief judge of the Supreme Judicial Court quite a few years. So he wrote this book on judges. So one of the things he writes in here is that age and health are important. And he indicates, although not always the case, that somebody with more years of life make better judges than those with less years of life, because of experiences you have over life and your experience through all of your successes and trials and tribulations. So he made this statement that he would like to see more judges that were 60 years of age or older. Good judgment, if it comes at all, comes with maturity. Maturity is the product of time and experience. So you fit that requirement, age. He also says, in considering a candidate for a trial bench, few elements are more important than litigation experience. So you fit that requirement. Judge Hennessy would be very proud of you for the amount of work you have done in the district and superior courts, trials you've had, and you've had. So those were two things that he thought were very important to have before you become a judge. And we have a lot of nominees sometimes that are in their 30s or their 40s, don't have experience either with trials or with life experiences that you would get at the age you're at. So that's always a good thing to have those. Let me ask you, I didn't know you were a yellow jacket.
For 2 years.
How come you didn't mention that in your statement?
Well, I didn't graduate from there. I went to AIC in Springfield for 2 years. I went there to play football, and it did work out so well, the football part. So then I went to Clark, and I graduated from Clark.
Who was the coach then, Salvucci?
Burke.
Yeah, so I went.
Although our defensive coordinator was Kevin Gilbride, who ended up being the head coach at San Diego Chargers.
Yeah, I attended AIC. I didn't know all these years we could have talked about AIC. Let me ask you, sentencing guidelines, what your thoughts are on those.
Well, as I'm sure you know, I was on the Sentencing Commission.
Yeah.
And my role there, of course, is being the representative of the Massachusetts District Attorneys Association, along with another assistant district attorney, was usually in the adverse to whatever they were trying to put through. Although it certainly did open my eyes to just, well, really talking to some of the other members of the board, what's going on in other counties. You know, like the way we run things in our county is so different than the way that they're run in other counties. And it was just very,
Sometimes that's a good thing.
well, I mean, that is, it was compared to what I was hearing from what was going on in other counties made me feel good about what we were doing in our county. The guidelines are just that, they're guidelines. First of all, they're not official. They have not been endorsed in any official capacity. And they do, they're guidelines. I mean, if there's something you can look at, if you don't have no idea about what to do with a certain case, it gives you a range of things that you may want to at least, you know, give you an idea about where you should start from and where you should end up in terms of sentencing somebody. But you don't have to follow them. And depending on the situation, I don't know that I would follow them. Now, I was also on the Superior Court Working Group for better practices in the Superior Court, and they did recommend using the guidelines more than I think I would have had it been up to me to recommend using the guidelines. They almost wanted to mandate the using of them when trying to come to a finding of a sentence. I don't think that I would use them just to be aware of what other people think should be done in certain cases, especially if it was a case where I didn't have any experience with before and just needed to kind of have a starting point from. But I don't think that I would consider them to be anything more than just that guideline.
Well, the problem I see with the guideline, and everything you say is true, it is my understanding that the legislature, the only body in the Commonwealth that can set a penalty on a criminal matter. Those guidelines haven't been approved by the legislature. And since our birth of a state in 1780, we've had a lot of cases go through our criminal courts, hundreds of thousands of them, without guidelines. And with what happened in the federal system with guidelines and how draconian they were for so many years, I kind of amazed that anybody would ever want to bring up guidelines again because of what happened down in that building by the water with those guidelines. People put in jail for 20 years for possession of marijuana. It was incredible. So I'm a little amazed that we would even be talking about guidelines. The record all they were used for. But what I find is if the guidelines benefit prosecutor, they're brought up. They benefit the defense lawyer, they're brought up. So they're used by the parties if they're favorable. But also, once they're brought up, seems, not all judges, but some, seem to stick with that figure as a starting, making this up. Let's say it's 5 years. Well, that's where the discussion starts. And to me, trying to get uniformity, like trying to get everybody to wear the same size shoe. Everybody's different. County is different. Every crime is different. So to me, bringing them up in the first place shouldn't be done. Totally against guidelines. I don't think they're fair. I also think there's a hinge of racism in, because they use whatever somebody had for prior records. And we know that the minority community in this Commonwealth gets treated differently than the white community by statistics. And Judge Hennessy's racism, that Judge Gance's study that he commissioned at Harvard bears that out. So when the minority communities who interact much more with police than some white communities, chances of going through their upbringing, so to speak, as a minority member, you're probably going to run into contact with police. You're going to be charged with a crime, even if that crime is dismissed or found not guilty. So to me, it's slanted that way. Another reason I don't think they should be used or even talked about in the court. They serve no purpose, the guidelines. I don't know how you, the group you were on, ever got to the point where an assault and battery required X amount of time, or a rape required X amount of time. I don't know of any studies I've read that clear out the fact that somebody charged with a crime should get this certain sentence. Remember Judge Harrington in the federal court?
Yes.
He refused to use the guidelines. He thought they were unfair, draconian, and the citizens of the United States were being used. They were used against citizens of the United States in a way that contributed to the unbelievable statistic that we have more people under lock and key than any country that ever existed on the face of the earth. I think that's one of the reasons why we have that terrible statistic. So I heard you, and I respect what you said. And without, let's assume Attorney Juvenile did a whole lot of studies, came into court, who were sitting. I said, Judge, I have juvenile guidelines. You would say, sit down, not use it. But not so with this thing that's came into existence in the state without, in my view, any real authority that says that you should sentence somebody for a crime. So I like what you said about it. I'd like it better if I heard you say on the bench, I want to hear about guidelines. I've never walked into a court or a clerk's office and seen a file. It was sitting on the counter. I look on it and it's dated 1955. I say to the clerk, this case is still, well, we haven't been able to sentence them because we don't have the guidelines. That's never happened. Judges like Judge Harrington used, he said, what judges have used forever concerning the crime, the victims, defendants' backgrounds, so forth. So I'd ask you to consider that. Second of all, they're doing much more continuing a lot of findings in the report than ever did. I first started. Sure. Counsel Kennedy. Readington would be great. So how do you feel about continue without a findings in the Superior?
Well, a continuous sort of finding, really, it's just another technique, I suppose, that you can use in your arsenal of sentencing alternatives. In the district court, they used to have what they call the Duquette. So if somebody got a continuance without a finding, they would not, originally they would have been able to come back and they'd go back to stage one and they'd be able to have the case tried anew if they violated the conditions of the continuance without finding. With the Duquette, though, aspect of it, you wouldn't. A guilty plea would enter. I think in the Superior Court, I'd be more comfortable if there was that Duquette aspect to it. Because if you were going to, why wouldn't you do like a pretrial probation as opposed to continuance without a finding? But I'm not against the idea of continuance without a finding as another opportunity to give somebody a chance to show that they're able to succeed. The problem in the Superior Court is generally the crime's a little more serious. And I'm trying to think of, but there would be crimes where that would be appropriate, not a lot. And if it's appropriate, then I'm not against it.
Yeah, it seems to me the only thing different in a guilty plea, getting a guilty or continue without a finding, is saying the word when asked, is that what happened? The defendant says yes. That's the only difference. The sentence is the same, usually. So, to me, this idea of having to have everybody admit their guilt before we can move forward is something that I don't agree with. I grew up Catholic. And every Saturday, we used to have to go to confession. Well, with religion, but there's people in this room that remember you had to go to confession just about every Saturday. And you went into some booth with a priest, and you would tell him what you did wrong. You did admit your guilt. The only problem was everybody lied about it. No one ever told the priest what they really did. It was all a farce. But unless you did that, you were in trouble with the priest and the time. So this need of having somebody say, I did it, I don't get the point. Especially when we know anywhere from 10 to 15% of the cases that are in our courts, the person didn't do it. But there's no exit from somebody who didn't do the crime from our criminal system, usually. So once you're charged with the crime, you usually have a choice of either pleading or having a trial. So for the person who really is innocent, he's in a tough position. If he takes it to trial and loses, he may go to state prison. He makes an admission, he may get probation. So the only out for him, even though he's innocent, to admit he did the crime. But for those people, when they started the no-fault divorce, before that, there was no fault. You had to have one of the categories of divorce to get divorced. Usually people chose assault, cruel and abusive treatment. So every day in the Commonwealth probate courts, there would be people getting their divorce, and a judge would ask, usually the wife, what was your health before you got married? Oh, it was excellent. How's your health now? Oh, it's terrible. And they go through these questions. Everybody in the room knew that the person was committing perjury, because it was the only way to get divorced, unless you had one of the other categories. But the judge knew it, the lawyers knew it, everybody else. But in the criminal system, there's really no way out of it if you are completely innocent, other than to plea or take your shot at a trial. So these continue without a finding where you don't say, I did it, sometimes it's very beneficial for clients, because they say, I can't admit I did it, I didn't do it. So not having to say that, I think, makes the system a little more effective. By getting rid of the case, the punishment's probably going to be the same. And so not saying I did it is the only difference. So I know you as a very fair man. Cases with you over the years. And I think you can be strict, and I don't mind that. But I also think you're extremely fair decisions you've made. I always say to people, but you kept going back to Brian. Kept begging stuff. He'd usually come down and give you something for your troubles. I always thought that was a nice aspect of the way yeah. So I think you're going to make a wonderful Superior Court judge. I'm be proud to vote for you next week.
Thank you. I know Councilor Kennedy, I think, has to attend to something urgent this afternoon. We're going to go with you next, sir.
Thank you very much. I appreciate that,
Of course.
Chairman. I have a few questions for you. We've talked a lot on the phone and had an opportunity to talk to you before you came in here, and had a nice conversation with your daughter, who gave you a good solid C+, so I'm going to probably vote for you. My first question has to do with the Dukin thing that you raised, because that's been a pet peeve of mine for years, that there are a lot of people that are still staying convicted because of the Hinton Lab scandal. Your son's boss recently petitioned the SJC to throw out all the cases that went through there in Suffolk County. How do you feel about that?
Well, my role in the Dukin matter was basically going through the cases that our office had where, number one, to determine whether or not she was or wasn't a chemist.
What difference does it make? The
Well,
the lab was tainted.
Well, I think that's what the investigation needs to determine. I mean, was it tainted to the point that all other tests now are in question? You know, I'm not sure that that's the case. And again, like I said, I didn't do a lot of drug cases when I was going through my career. I did mostly the child abuse cases, which is why I volunteered foolishly to do the Dukin matter and for our office. And so I wasn't really focusing on, was it right, was it wrong? It was just like, what do we have? What's the damage to our office? And what is the possible ways around it? And when we first started, you know, there were some things about was she the only chemist on it? Was there another chemist? Do the drugs still exist so it could be retested?
Taking drugs from other people's.
Right, I'm not questioning the result that the SJC came down with as the way to resolve that matter. I'm just saying when we started, it was very intricate in terms of what are the possible remedies, and we've looked at them all. And in the end, I think they did the right thing. Now, if you're asking.
I agree with you. When you started, it was pretty complicated. Nobody knew how far reaching it was. And the same issue in Western Massachusetts as well with Farag. But my question to you is simply this. Annie Doken admitted to altering samples that she did not test, to taking drugs from, replacing it with other stuff. How can you trust anything that came out of that lab?
Well, like I said, is there an investigation that leads to questioning the integrity of anything else that was done there?
We're 8, 9 years out. Right?
Right, but you know, this is drug testing where there's lots of records kept in the ways in which they were done. And so you can look, and I think they've done investigations into that lab and they haven't found that there was anybody else other than perhaps a lack of supervision over her.
What difference does it make? She admitted that she altered other people's samples and you'll never know which one she touched. You'll never determine that through an investigation, ever. You'll never know if she added powder into a cocaine bag that she didn't test to take it, to put it somewhere else. You'll never know.
Right, these are the factors that I would need to know before making a statement about what should be done about the lab. If, as you just portrayed, that is what happened, if she was found to have taken samples from other people, then that, I'm just saying, if that's, I didn't do the investigation into Annie Dukin. If she admitted that, that calls into question all of those results.
Right.
Right,
So
and if
find
somebody
the
can show that
outcome.
that happened, that's a serious issue that needs to be addressed.
Okay, so you're a Superior Court judge. I got a guy with the conviction that came out of the Hinton lab. Annie Dukin didn't touch it. I'm bringing a motion for new trial. And you know that she altered other samples in the ad. I can't prove it with the specific one, but how can you trust that sample?
Well, I assume from that, we are assuming that she was working at the time that that testing was
Yes.
done. And so she would have had access to those drugs.
We are assuming that, yes.
Right, and you know,
I
obviously.
can't prove that she went into that sample.
No, I understand that, but you know, to me, that's where the advocacy from the defense attorneys becomes so
I've given you
important.
all the facts.
To
That's
let me know that that's the situation there, and if the burden shouldn't be on you, let the Commonwealth show that she didn't tamper with those drugs.
What's the standard for that?
What's the standard for what?
The Commonwealth's burden at that point. Is it proof beyond a reasonable doubt that she didn't touch those samples? Is it preponderance? What's the standard that the Commonwealth would have? You said put the burden on them. What's the burden?
I would certainly want to see if there's any case law that says what it is.
There isn't.
But if there isn't, I would say that it would be just a preponderance of the evidence.
I think it's too low. I disagree with you completely on that. I think everything that came out of that Hinton lab, and I've said it for years, should be thrown out, every conviction, because you can't trust any of them. Okay, I'm gonna talk to you about a pet peeve I have that's been ongoing over and over and over, and I keep yelling at judges for it. Okay? Let's start with 58 days. Okay? Because it mostly deals with 58 days. Do you think 58 days are overused throughout the Commonwealth by the prosecutors?
That's a difficult question to answer because I certainly am in no position as a judge to question whether they should be used or not. There's a procedure that's outlined and certain requirements have to be met before they can use them. Then you have to,
They're very minimal.
Well, I know,
It's based on
but-
what the charge, somebody's charged with the violation of restraining order, it's a qualifying event,
Mhm,
okay? Might have no record, but it's still a qualifying event, right?
correct.
So it's very low in terms of when it can be brought. Do you think it's overused by prosecutors, especially frankly in the district court?
I would think that there would be times where it is, I'll tell you specifically when you find that some offices, not mentioning any offices' names, offices, not officers, they file the 58A, and then they withdraw it after the time, after they've held the person because they'd
3
rather
days,
just ask,
one of my pet peeves.
want to ask for bail. And I think that's,
Or they agree to conditions 3 days later,
right, I think that's almost an admission that they're using it incorrectly.
you know? And people are taken, they're ripped from their homes, they're ripped from their jobs. People who have never been in jail and may never go to jail on that case have just spent 3 days in jail. You think that's right?
No,
Okay, so 3 days later, the prosecutor comes back and says, we're gonna agree to conditions. Okay, we're gonna put this guy on drug testing, and we're gonna tell him, you know, we're giving it an 8 o'clock curfew. Okay, I'm the defense lawyer there, we sign off on it, we all agree to it. And this is where my pet peeve comes in, it happens over and over and over. And by the way, most of the judges I speak with think that the filing of 58 is abused throughout the state by prosecutors, mostly young prosecutors. And I agree with that. I think they file in too many cases. But what happens is we got a guy out there, and happened to be very recently in the case, that is accused of violating some condition or other. Probation brings it into you, the prosecutor, and says, John Smith flunked the drug screen, or John Smith got thrown out of a program, okay? So you walk into the courtroom as the prosecutor, say, probation gave me this, judge, we want a warrant for him, right? Happens all the time, right? You agree with me?
I don't know that we're asking for probation warrants. Why isn't probation asking for the?
It's not a probation warrant, it's your case, it's pretrial conditions of release.
Okay, so then and he's violated a condition. What's
Allegedly violated the condition.
Right, but
And
they
you
have,
walk into the courtroom and said, probation gave it back to me, he flunked the urine, we want a warrant.
I think I need to know what is the underlying crime?
Well, here's my question for you, and it happens all the time. I'm the lawyer on the case. There's a defense lawyer. Why aren't I told before you're going before the judge? Why aren't I getting notice? Every defense lawyer I know in the world has a cell phone. Every single one of them. And a phone call could say, hey, Terry, your client, there's an allegation your client flunked the urine. We're bringing it forward. Do you want to be heard? And you know what? I don't have to drive down to Boston to be heard because I got this great thing called Zoom. Why aren't I told? And it happens over and over and over and over. The DA is going to get warrants without giving me notice first. The case that I had the other day, I got a call from the probation officer saying, I gave it to the DA, they got a warrant for your client because he got thrown out of a program. Do you know what the problem with that case was when I looked at it? There was no requirement he do a program. The only requirement was that he submit to random urines. He got thrown out because his roommate got caught with packaging for Suboxone, and they threw them both out of the program. He was in there voluntarily, and the only thing that shifted was instead of doing the urines through the court, he was doing them through the program. That's all that changed. There was no requirement of a program. And they walk in and get a warrant. Now, I'm told ahead of time, I can say, Judge, that's not a violation, right? But yet, there's a warrant for this guy's arrest. Some police officer's gonna knock on his door, place him in custody on a Friday night, and he's spending 3 days in jail for violating a term that didn't exist. My point is, why are prosecutors throughout the entire state going in the courtrooms without notifying defense lawyers? I'm a party to the case, I represent a party in the case before they go in. Happens every day, all over the Commonwealth. You think that's right?
I don't think it's right. You know, unless there's an issue of public safety, which would be rare
I
in a
get that.
situation like that.
I get that, I
You should
agree.
know.
If somebody's a danger, that somebody's gonna get killed, somebody's gonna get murdered, but the odds are, if it's that bad, they're not on the street, right?
Right?
I guess in a situation where there's a GPS with a stay away zone from a victim's house and the GPS is showing they're at the house, that might be an emergency situation. But that would be extremely rare. Can you ever see a scenario where somebody flunks a urine that you should be going in and getting a warrant on someone without notifying their lawyer?
I cannot think of a situation off the top of my head, and I
And-
would like to see one so that we don't know of one if there was.
Do you see it? Do you agree with me that it happens every day? I'm sure it happens in Barnstable. It happens in Middlesex. It happens in Suffolk. It happens everywhere. I get the phone call after the fact. If I get a phone call, a lot of times I don't. A lot of times a warrant's sitting on my client's, in the docket for weeks or months till the next court date comes up and I show up with them and they say, oh, he's got a warrant. It's not on today. Sometimes I'm never told. Pet peeve. Doesn't happen so much in Superior Court. I agree with that. It's less in Superior Court because they're monitored more closely and you're usually in more communication with the lawyers involved. You know how it is in district court. The young DA will, whatever's on the list that day, might not even know who the lawyer is. And I don't blame the young DA. You know who I blame? I blame the judge. And I tell them that all the time. They should be saying, have you notified Mr. Kennedy? Have you notified Mr. Juvenile? So we can set this up for a hearing as to whether there should be a warrant. We set up at 2:00 in the afternoon, right? Pet peeve. Okay. There's other things I'm going to mention to you, and then I'm going to leave because I do have to do some things. First of all, Councilor Iannello spoke to you on the phone yesterday, and he's a big supporter. He wanted me to indicate that he enjoyed your conversation and that he intends to vote for you next week when your name's put up. And the second thing, you gave a really interesting answers to one of your questions on the Governor's Council questionnaire. And usually most people say, yes, that's the response we get. Yours was very interesting. Do you feel the present compensation levels for judges in the Commonwealth of Massachusetts are adequate? And your answer, becoming a judge is an honor in and of itself. I would hope that the salary of a judge would be commensurate with this great honor. That was a great dodge. Spoken like a true lawyer. Yeah, my opinion is they're underpaid. But that's just my personal opinion. I think they're underpaid, significantly underpaid, and always have been. You make less than a first-year lawyer at a big firm, and you should be making more, especially in the Superior Court. But I love that answer. Thank you for your time. Thank you, Mr. Keel. I'll be voting for you.
Thank you, Councilor Kennedy. Councilor Devaney.
Thank you.
You're welcome.
Nice seeing you again.
As you
Thank you
think.
for all the time you afforded me. I think it was 4 hours, right? First of all, I can't say enough. It's so impressive. And I can't tell you how welcome I am to have you be nominated. Because we don't have everyone with your qualifications or even close to them coming. Now, I asked you, how many cases have you had in your legal career? And you answered,
Too many for me to give
Too
an
many.
accurate count on.
okay.
Yes.
Now, let me tell you why it's so important for me to have you nominated. People think we have so much power. We don't have any, really. I only have the authority to vote yes or no. The governor appoints 21 attorneys, and they are charged to decide who's going to get interviewed and who's going to be recommended to the governor to come before us. There has never been 21 attorneys present at any hearing. Okay? I can't change that. It's wrong. They have an awesome responsibility to give someone a lifetime position, and you don't even have 21, but they vote. Years ago, there was a JNC chair, and he told those 21 lawyers, if you don't go to the hearing, you don't vote on the nominee. Isn't that wonderful? You know how far back that was? That was Governor Salucci's administration. So I can't change that, but I'm just saying it for the public. It doesn't go to you because people think that, we have all these names and we choose someone. It's not that. So sometimes people come through that are absolutely political, not qualified. And I'm saying it because I don't have a poker face. I am thrilled you're here. Okay? And just as example, not politically correct, we have someone that 4 years ago was brought up to the Superior Court, Salim Rodriguez, 6 cases in 21 years in the Superior Court, and you can't even count them. And I'll tell you why I like your criminal experience. I have my own philosophy, and I shared it with you. I think if you have an attorney that has not had criminal cases and is is a judge in the Superior Court, that judge will be timid to give the correct sentence to a criminal. And that's my biggest concern. So not everyone sitting in the court are qualified, unfortunately, not with my vote. But I'm saying that right in the beginning, and I never do this. But in 21 years, I have never seen the experience that you've had. And not only that, but I have said it publicly, I won't vote for anyone without empathy, without compassion, and you have it. In all the letters that we got, all say that. So that's very important to me. So I'm doing a lot of talking, but I usually don't put that forward. I vote next week, but you know what? That's not true. Oh, and I got to tell you about that other fella. We never went to the assembly like we will next week to vote for you. Lieutenant Governor came in, we voted while I was questioning him at the hearing. Anything goes up here. So that's why when things are right, we have someone like you coming in, I really welcome it because I have no control of all of the politics that goes on. So having said that, okay, so now, in addition to everything that you've done in your legal profession, you were an Eagle Scout. Now, people might not know how difficult that is to be an Eagle Scout, and you're still involved with them, with the Eagle organization. And to me, to have any child that would go to those years, were they about 18 probably when you become an Eagle Scout or close to it?
16.
16? I mean, in this day and age, in this society, for any youngster to do that, and thank you for your involvement. And you've been a coach for basketball and soccer and t-ball and everything else. And, so you do care about your community besides your, judicial responsibility. We went through a lot of your cases, which I don't know how you sleep at night. It is unbelievable, but someone has to do it, and you have chosen to. And I just want to talk about some of those cases that really, really are, I can't even imagine. So let's talk about your writings. I was very impressed with your writings, and I told you, I just heard a year ago, there was a Superior Court a couple of years ago that he had been appointed to district and then Superior. And then he decided, too much writing, I want to go back to district. It doesn't come back to us, believe it or not. So that's all done, there. So I'm impressed with your writing, and it's important. Tell me about that case that you included in your resume, the writings that you put.
The one that I chose the writing sample from?
Yeah.
That case was an old unsolved case that technically is still unsolved from Falmouth, where it was the Rainey case. And we had investigations ongoing, and eventually it kind of headed towards one individual, the person who got charged. And he was making statements while I was in jail about having been the person that did kill the victim. So we put as much together as we could, and he was charged. Now, there were interviews with him probably, and I don't know the number right off the top of my head, but I'm going to say about 5 or 6 different times. And what was interesting in that case is that Chris Mason, who's now the colonel for the state police, was, when we started that case, a trooper. And I think when we finished that case, he was a captain. And so there was a motion to suppress the statements that this individual made over a long period of time. So for each one, when I'm trying to refer to them in the motion, I had to say like, well, it was, Chris Mason, but I refer to what his rank was at that time. So you'd be saying, okay, so he's trooper, he's captain, lieutenant, captain, all that sort of stuff going through the time. We succeeded on the motion to suppress the statements. So we were able to use the statements that he made. We're basically jailhouse confessions. But we didn't succeed at the trial because there were jailhouse confessions, and there's a number of reasons why people will make jailhouse confessions. That could mean that they didn't commit the crime. It could be because they're just trying to get some cred while they're in jail. And so they're going to take credit for doing a crime they didn't commit. And if it's just a confession, even if you've made it 2 or 3 different times, you have to have evidence backing it up. Well, when we indicted, we certainly thought we had evidence to back it up. And I'm sure that when he was indicted and, that case was not required out, so the judge had found that there was enough for it to go to the jury. We were certainly legally in the correct position to have taken that case to trial, but there wasn't enough for the jury to convict him, and he wasn't convicted. He was acquitted.
Okay. So you've had a lot of child abuse cases and murders. The one thing that bothers me, a lot of things that bother me, but in particular, when they find the person who is the murderer of a child, there's always a woman involved, but she walks free because she went along with the court and everything. And I know that has to be, but it bothers me because that person is just as guilty, was with that person, and supported the murder of the child. And there's more than murdering a child. Abusing a child, they affected all their lives. And there was one that was so egregious. First of all, I'm going to ask you, is there any one case that stays in your mind? Maybe you could call it that it was not justice, but you had to live with that decision. Is there something that you can think of?
Yes, there's one case, and I apologize if I start to digress a little bit, but I think it's important for you to understand so that the whole thing makes sense. We had a boyfriend and the mother of the victim were both charged with indecent assault and battery and rape of this child. And the allegations, without trying to get too graphic, were basically the mother would hold the child's mouth open so that the boyfriend could do something, which was illegal. And we originally wanted to try them both together. Judicial economy, it's one singular event, and we have one witness to say that it happened. And the judge continuously asked both of the defense counsel, is there any reason why this case should be severed? Are there any inconsistent offenses? And they, nope. So the boyfriend's attorney makes his opening statement, and the basic defense is, we're not saying this didn't happen. We're just saying it wasn't him that did it. It was some other boyfriend. Well, that's an inconsistent defense. The judge said, no, we're going to have to sever these. And whereas we wanted to try the mother first, because the child was in custody of relatives of the mother, and as long as the boyfriend was still outstanding for trial, we thought that we would be able to, the child would be more interested in testifying against the mother and then the boyfriend later. But we couldn't do it because he made his opening. So the judge said, no, we'll go forward with the boyfriend. We go forward with the boyfriend is convicted. I think it was a year went by, it's the mother's time to be tried, and she is tried, and the child was fantastic. Came in, and I remember her saying, are you ready to go and testify? And she said, yeah, what mommy did was wrong. And she just came in and said what happened. The mother was convicted, and the judge gave the mother probation, and I never understood why. And I think that this is a good lesson for me, because if I am a judge at some point, I think this is the kind of a case I think you need to say why you're giving the sentence. I'm not saying the judge gave the wrong sentence. I'm just saying I would love to know why they gave the sentence they gave, which was probation. And all they said was, she's a mother. And I just didn't understand that because she was a terrible mother. She's not good at being a mother.
I know.
But that's what the sentence was. And that's bothered me, to this day. I just don't.
I remember reading that one. No, you can't get graphic. But she was a 2-year-old and the mother held her, their mouth open
Right.
for the father. And I'm saying, I cannot imagine in this day, in this century, any judge would say, I'm giving her probation because she's a mother. I mean, the definition of a mother is not what we see now with these women who are killing their children, abusing their children, or helping their boyfriends and husbands kill their children. But to me, to say she's a mother, that judge shouldn't be sitting on a bench, because that's not what our mothers were. That's not a mother. And that child was 6 years old. And that is amazing that that little girl had the courage to go to court, and I read it, and she said, what my mother did was wrong. Isn't that amazing?
Well, she did it twice because she testified in the first trial and in the second trial. So,
Yeah,
like I said, she was a great, just a really strong little kid. And I think that she one of the ones you meet, you'll say that she'll be able to get over what happened with the appropriate, services and stuff. But, it's hard to keep in touch with a lot of our victims, because when we see them, they know us for the terrible thing that happened to them. And if I were to run into her on the street and I started talking to her, I'd just be bringing back memories, which would be bad. But I'd love to know how she's doing.
I hope
today.
that mother never had custody of her after that.
She did not, as far as I know.
Yeah, there was an aunt or something I
Right.
read.
There was a granddaughter, very
Yeah.
interesting.
It's, no, it is disturbing. I remember, there's so many, Bella, that was missing for so long, and the mother said, oh, she's sleeping or she's away and everything. And she was in a bag in the river, and she had her in the back seat with her while her boyfriend, and she walked free. I can't change it, you can't change it, but it just is wrong, So, what I do want to do, I do want to interrupt this, because I want to say that I have never, in 21 years, got 11 letters for you, 11. And I know the counselor has mentioned it. We can't read them all, but I just want to read just, something from all of them. And we got one from Mary Ellen. It's very hard to read. Yeah, Mary Ellen Alcada. I can't read it, but anyway.
Counsel Devaney,
She's from the trial.
Counsel Devaney, can I just interrupt you for a second? I could have read them all in myself, but I chose not to.
Okay.
So I'm just going to ask you, if you
Thank
don't,
you.
if you want
She's
to pick a
from-
sentence or two, but I don't want all,
Thank you very
11 letters
much.
being read.
It's from the trial court, Superior Court in Nantucket.
Mary
and-
Elizabeth Adams.
Yeah, and she said that your upbeat, positive engagement, and to resolve issues, always a smile in your voice, balanced and respectful to all, prepared, attention to detail with compassion to the jurors, witnesses, and families of both the defendants and witnesses. From Michael O'Keefe, he said you integrity, has intelligence, preparation, fairness, has a comparable breadth of experience civilly. And then we have from, as was noted, Sharon Thibault. And she said that you train prosecutors in-house and at statewide conferences, as well as local police and medical personnel of various legal issues. And you screen every department of children and families, referral to the office, and serve on the board of directors of the local child advocacy center. And you patiently walk all of these through their situation. And your goal is to seek justice. And I wish I could read all of them, but we'll provide these for you. I think you'd want to see them. And then from Michael Trudeau, he said that he's known you for over 30 years, competent, hardworking, conscientious, fair. He says a lot more. And then we have Judge Rufo, and he said a lot of good things. He said he tried numerous first-degree murder cases before him, as well as maintaining an active practice involving complicated patents and legal issues. And you've tried sexually dangerous persons with the Commonwealth, and civil commitment to the Massachusetts treatment at Bridgewater. Ethical, excellent interpersonal skills, maintaining a reputation to the legal and local community. And he also talks about your involvement with the YMCA basketball and all of that. And he said that, talked about your participation in the Supreme Judicial Court's reinventing justice programs and the trial court strategic planning initiatives. And so the reason I am bringing this is because it wouldn't come up in this hearing, and I think it should be on the record what these people said. And from a trooper talking about Christopher Mason that you mentioned, and utmost integrity, it talked so much about you. And William Robinson said that you worked together for over 21 years before his retirement, and he said you were gracious, whether you won or whether you lost. He said a lot of other things. And then William Burke, Sergeant, Massachusetts State Police, retired. He said he worked with you for 23 years in child abuse and homicide investigations, and you you were fair and objective with people, and you will be such an asset to the Superior Court judge bench. And then Drew Segadelli said that he's tried numerous cases. He was your opposing attorney, and he said that you were a zealous advocate, embracing a philosophy of recognizing in human nature the difference between bad decisions making versus pure evil. And Peter Lloyd said that you were prepared, prosecuted hundreds of cases, homicide, sexual assaults, and violent crimes. And I'm going to ask you about this, that you presented the first shaken baby case in Cape Cod. And sexually dangerous persons, civil commitments, and represented Barnstable County in civil litigation. And also Robert Manning, First Assistant, Barnstable Superior Court. He talks about that you're a gentleman and you treat people with respect and kindness. And you have a desired judicial temperament. So there's so much more that they said, but I just want to put that in the record because I think that that's very important. About the shaken baby, I had a friend whose grandchild died, and I know it's very hard to find these people guilty. And unfortunately, this woman was guilty, but she was found not guilty. And she was a neighbor of the couple and took care of this 18-month-old baby. And the judge ruled that she had did everything she could. She called the ambulance and everything, but the baby died. And they really believed that she did it, banging the baby against the wall and stuff. So I'm just wondering, where you were the first, tell me about that, how difficult that was.
Well, all I can say is like, I don't know if there was any other one before that. I was not aware of there being another one before that on the Cape. There may well have been cases where it was shaken baby, but no one knew it was shaken baby.
Right.
But our case came up after the Woodward case up in Middlesex County. And it was actually continued once because of the publicity that was generated by that case.
Yes.
Made it difficult to be able to get an impartial jury. And that case was a cooperative effort, and the medical aspect of that was so important. In my humble opinion, that case was won because of the doctors that came down from Children's Hospital and were able to relate to the jurors what the different findings that they had made were related to being shaken and the way that they were shaken. That baby survived and was, I think, 4 years old at the time of trial.
Can I ask you something? The brain is so delicate. Even if you did that to an adult, I mean, the child must have some kind of brain damage.
Well, there was residual injuries, and that's one of the things is like that was very important when they testified, saying, it's very difficult for them to say today what the effect is going to be somewhere down the line, because, child's body is very resilient and they're going to be able to heal a lot better than even adult
Yeah.
brains would be able to do.
But even down to learning disabilities. Yeah.
Right, and so that would be something they're gonna have to watch and
Right.
test with the child. That child had some deficits even at that time, though, at the time of the trial with eyesight and things like that. So, like it was a long case, the experts, which were great in time, taking time out of their busy days to come down and testify at the case. And they were really the ones that presented a compelling case for the jurors to find the guilt in that, which they did.
Yeah. So when you were asked about favoring further limits on discretion through legislation, I agree with you. I think the judges should have discretion. And you said at the end that hopefully that they will consider the unique circumstances that make cookie cutter sentences impractical. And you are referring to the legislators, and you think a judge should have the discretion to weigh each of the factors fairly and appropriately, and all factors should be weighed the same in every case. I agree with that. So, with all the cases that you've had, there are some still open, aren't there?
Well, they're on appeal. I don't have any open cases left, like pending in court.
Yeah.
I mean, I've given them away to other people, so someone else in the office is doing it.
Yeah, right. So, now, there was you've had poll cases too, right?
Yes.
That's amazing. And I don't know, I'm going to say it publicly. I'm concerned about a case that we had in Watertown. We had the first Black woman police officer in the history of Watertown. And I liked her. She was tough. She was good. She was from Roxbury. And anyway, she was being harassed, and I won't get into it, called the N-word, touched improperly, all that stuff. So anyway, she sued, she left. 2 years later, she was killed. And we never found out who. And it's been about 22 years now. And she was killed in her apartment in Roxbury. And I'm concerned because I just think, I have a philosophy, a Black woman killed in Roxbury is a one-day story. And I'm hearing rumors that they're going to open that case, and I'm praying they will be. I don't know who to go to. Probably never find out who did it. But though I'm very pleased that you've been involved in those. And the one that I'm looking at is the Martha's Vineyard aggravated rape case. That was the Butler, Brian Butler. And why don't you tell us about that?
Well, briefly, what happened there was a woman was walking home from a restaurant in Tisbury, Vineyard Haven, and somebody ran from across the street, dragged her up into the woods, tied her to a tree, and violently raped her in more ways than one. Left her tied to the tree and then went off. She had to actually use her teeth to untie herself and then go to her friend's house, which is where she was heading in the first place. The police were notified. An investigation began, but there were no suspects at that time. So that lingered for a bit. And then I think it was 3 years later, near the same area, somebody grabbed a jogger, a female jogger, and tried to pull her up into the same wooded area. But she was able to get free, punch the individual, gave a description. This Brian Butler was identified by her as being the person that did it. So he then became not only the suspect in that case, but the suspect in the first case. There was some forensic evidence that was found. It was able to tie him into it. He lived in New York. The person that was the victim in the case lived out in San Francisco. So the police went to New York to talk to Mr. Butler, who gave a statement, which then led to motions to suppress, which involved conflict of laws. And then out in California, there were some questions about whether or not the victim had got hypnosis in order to help, strengthen her memory. But fortunately for us, before she left, she'd given a full interview to the local newspaper describing exactly what happened. So she had a if there even was hypnosis, hypnotic memory that we could demonstrate and show what had happened. So he ended up getting charged with her case. And he was convicted, and then just recently, we got notice that he was going to be released from serving his sentence, and the victim in the case actually called me. And it was just nice to be able to speak with her again, because again, we can't reach out to the victims because it just wouldn't be appropriate, because the only interaction they had with us would have to do with this terrible event that happened in their lives. And we don't want to dredge up those old memories. But it was good to talk to her and hear how she was doing. She was an artist, and she had some medical issues at the time and things like that, which is one of the reasons she wasn't able to get herself away in the situation that she had found herself in. And it was just really nice to hear that she was doing okay. She was afraid that he might come after her, but hopefully we were able to assuage those worries just because of the time that had gone by. And, the last thing that this individual wanted to do would be anywhere near where she was, because that would be a reason for him to be charged with something and know where she lived. He doesn't have access to find out where she lived.
And you had I believe it was the first caseworker killed by a disgruntled client.
ESS worker at the time, up in Provincetown, yeah.
You know what I have noticed and I'm impressed with? Practically all of these cases, these murder cases, ended up with sentencing without parole. And doesn't bring back the loved one, but at least it gives them some, to know that justice was served, So, yeah, I'm not going to go through all of them, but, you have the ability to work with people. You are a mentor. You supervise large staff, attorneys, and so many other people that, I don't have words how happy I am that you're here. I wish we could clone you. And thank you for all the time that you took with me. And you are on the Hall of Fame now.
So is Heather.
If the people don't know, that's that's the Waffle Hall of Fame. So thank you again.
Thank you.
And congratulations. I look forward to seeing you on the bench.
Thank you, Council Devaney. Council DePaul.
Thank you, Mr. Chairman. Good afternoon, Attorney Glenny. You're a man after my heart, referring to Worcester as the big city. Designation, it's well deserved as the second largest city in New England. There were a couple great issues brought up already today that I won't iterate, but in particular, Councilor Kennedy's comments about the drug testing. To me, it's beyond a pet peeve of his. It's an injustice, and I suppose that comes down to what we view justice as. But I wanted to pick up on something Councilor Juvenile talked about. Cannabis. In your experience as a prosecutor, do you think that the decriminalization of cannabis has been a net positive or a net negative for the Commonwealth?
I really have not had something I could point to right now because of the cases that I do.
Yeah.
Like I said, number one, that would be more of a district court kind of matter, I would think. I've not had a child abuse case where somebody has said, like, I was so high from smoking pot that it caused me to nothing like that. So I really don't feel like I'm in a position to say anything because I've not had any experience with that, with the kind of cases that I've done.
Okay. You attended Clark University.
I did. Took some classes at Holy Cross.
Okay, not bad. So you're traversing the city. Kids at Clark smoke pot, right?
So I hear.
Do you think that kids in Maine South, for those who don't know, Maine South is a neighborhood in Worcester where Clark is. Clark does a great job of connecting with the community. It's a community that's been struggling for an awful long time. Do you think kids in Maine South smoke pot?
Now?
Ever?
Ever? I would imagine that they did.
Do you think that kids in Maine South are more likely to have been arrested over the years for possession of marijuana than kids at Clark University?
I would think probably, based on no empirical data that I have, I would say yes.
I would as well. And it speaks to some of the issues we'll talk about in a minute, but you're working child abuse cases. And when we talked, I mentioned that my first internship in law school was at the Child Abuse Division and Appellate Divisions at Suffolk County District Attorney's Office. And that was a real inflection point for me. Pretty much all of my professional career since then has been working with at-risk youth. kids who are dealing with significant trauma along the lines of some of the things we've heard about today. What are your feelings on raising the age of juvenile jurisdiction?
Well, I find that to be a difficult question. You have to have bright lines somewhere. I mean, like when you set the age of consent as an example, because, we're talking about child abuse cases. Why is it 16? Because if it's not 16, it has to be something.
Right.
There are going to be 15-year-olds that are more mature than some 16 or 17-year-olds. Just that there's going to be some 18-year-olds that are going to be less mature than some 14 or 15-year-olds. So the legislature has to pick an age, and they picked that age. Now, I believe there's science that shows, the development of juvenile brains. I think we need to follow the science. I think that you have to be able to look at an individual, if there's a way, if there's a scientific test that could be applied, say, for instance, that would show in each individual's case, how well developed is this brain, or are they able to perform executive functions, and to what extent are they able to perform those executive functions to the point where they should or could be held responsible for a crime that they committed, or could not be held accountable for a crime to commit. So I guess what my answer is my best way to try to get it both ways, I suppose, is saying you got to set an age. You have to set an age, and it should be based upon the science. But I do believe that there's circumstances where you could show that there's exceptions to whatever that age that's going to be set is.
Yeah, and beyond even culpability, merely as a mitigating factor, right? And we discussed, I mean, from my perspective, if we were to get to the point where we could have a simple test to evaluate someone's brain, that something that could be quick and cost effective, and we could introduce in court, I personally, I think our justice system would be alarmed at the fact that we're locking up a lot of folks who simply don't have the brain development for impulse control. So, an example I think about is a recent case in juvenile court that the SJC overturned, where a teenager, and I won't get into the details, facing a situation that clearly manifested from her earlier childhood trauma, was held in contempt for essentially telling off the judge. And this is a teenage girl. And so the way that our system sometimes ignores the reality of brain development and impulse control is really alarming to me. And it's alarming because the folks, the children who I've worked with, whether as an attorney or an educator, they're piling up records as juveniles. And a lot of times they're piling up records for behavior that is woefully undeserving of the punishment they receive. So children who will intentionally behave in a way that will get them kicked out of a group home because the group home isn't safe for them. They're willing to take that knock because they don't feel safe in a state-controlled facility. So it sounds to me, and I want to have clarity here, that brain development, especially in young men, that is, it doesn't excuse behavior, but that it's a mitigating factor that you would consider in all the instances where you have discretion to do so. Would that be accurate?
Yes, and the question then becomes, how would I become aware of those factors?
Right.
And I think that's where, the advocacy of the defense attorneys becomes so important, because if they have a client that they know has a situation like that,
yeah,
I think it's incumbent on them to make sure the judge is aware of that so that they do factor that in.
Absolutely.
So,
and even, I think about that young woman in the case I just referenced. I mean, I've certainly worked with people. I have contemporaries in my own life who, even hearing the stories that were brought up in this room today, would have been triggered to dysregulation. And I've worked with children who would have been triggered such that we would be happy that at least one of us in this room is trained in restraint. This is the reality of folks. And a lot of those folks are going to end up in our criminal system. And they're going to end up potentially before you in superior court. And it kind of overlaps with another big picture issue that I don't mean to speak to your specific individual experience, but to the systemic nature and your global perspective on it. Councilor Juvenile raised the Harvard study on racial disparities in our criminal justice system. you and I discussed that in some ways, there's a lot of data we wish we had that could supplement those findings and that could fine tune where we should be looking, if we should be looking, right? There's some data though that's not disputable. So in cases where there's charges with concurrent jurisdiction in district and superior court, we know that Black and Latino defendants are twice as likely to be indicted in superior court than district court. And obviously we know that that sends ripples upstream along sentencing too. And we also know that sentencing, and I'll read 2 sentences from the study, a Black defendant whose most serious charge is a weapon offense is sentenced to roughly 175 additional days of incarceration than a white defendant whose most serious charge is a weapon offense. This disparity decreases to roughly 125 days after accounting for case severity, jurisdiction, defendant demographics other than race, and neighborhood characteristics. So there's a lot of places in the study where I wish we had more data. And when we discussed, you agreed with that, right? But here, you know, if I'm controlling for severity of case, jurisdiction, defendant demographics, and neighborhood characteristics, and I'm getting 125 days more for Black and Latino defendants, that's really alarming to me. And I wonder what's your reaction to that? And by the way, those numbers I'm focusing specifically on weapon offenses. But what's your reaction to that 125 days?
Well, you know, if 2 people commit the same crime, they should expect the same sentence, you know, whatever that sentence may be. And I think it's not fair if one person, just because of their race, is getting more time than the other person is.
What if because of their race, and not because of their race, because some law enforcement officer or some judge decided to target someone because of their race, but what about in the big picture, the kid in Maine South compared to the kid in Clark who's coming at you with a different record? Same offense is committed, but you're looking at the record too.
Well,
You know, I mean, how does that overlap with the racial disparities we have?
that's a very complicated question, because when you start bringing in the record, which I think you should, I know some people don't think that, but I think that you need to take into account, because if you have a record that shows that a person has a predilection towards certain things, say for instance, you have a record that's replete with drug type offenses, that may be something that needs to be addressed on sentencing in terms of a term or condition of probation.
Sure.
If you don't look at the record, you won't know that that may be an area that needs to be addressed. Or you may find that this person has had, you know, 5 previous violent crimes, I think, and the other person doesn't, you know, irrespective of what the race of either of them are. I think that's a factor that needs to be considered as well. But there may be reasons why that is. And again, you know, you've got to put that on the defense attorney who knows the client to explain why that is, you know, and why you shouldn't be putting more weight on a certain aspect of a record as opposed to another one.
Yeah.
Because, you know, that's the time for them to explain that.
Yeah, and I agree with what you're saying, but I wonder, I think judges and attorneys have always had that perspective. I don't think anyone's been trying to do anything different, and yet here we are.
I
Right.
agree, but I will tell you, I will say this, you know, I was on the Sturgis Charter School Board of Trustees, and we're always trying to diversify our student body. And we're always trying a way to do that. And one of the things that we were finding was interesting, and I didn't mention it in this context, but I did mention this yesterday, is like, how do you identify the race of a person?
Yeah.
Is it because, you know, a genetic test was done, which, you know, conclusively establishes it, or is it a self-report? You know, in the Harvard study, they even said that in some of those cases, it would just by looking at somebody, they were accepting that as a reason for whatever the race may be. There's no easy way to do that, you know?
Sure.
And so it's a very difficult, but very real, you know, situation that we have.
So I guess what it comes down to is when this is a big picture issue that I don't think any one individual wishes to contribute to, but what can an individual do? Like what can we do in our small roles? So as a superior court judge, what could be done?
I think all you need is to be aware and try to always be aware, you know, and before you issue the sentence or whatever, you think back to yourself and say, now, wait a minute, is there anything here that even unconsciously that I can at least see that I may be doing? And if there is, try to address that right then. Now, like you said, you know, nobody likes to think that they're doing it, you know, and that's the whole thing about the implicit part of it, right?
Sure.
So it's a very difficult situation. All you can do is hope that you don't succumb to it, that you don't do it.
Is there a role for the judiciary and the courts to be filling in some of the data gaps that you and I discussed?
Again, it's a, how? Right?
I'm not up for Superior
No,
Court
I
judgeship.
mean, that's what you're asking me.
Yeah,
It's like,
yeah,
how
yeah.
could you do that? I mean, I suppose you could ask somebody, right? But then it's still self-reporting.
Mhm. Surely there will be a way. Would you support efforts to find a way?
Like we said yesterday, the
Yeah.
more data you have, the better it will be in the long run to be able to, overcome this, if we're ever going to be able to do it.
Right. And the last thing I want to say, and I won't iterate with questions, but one thing that I value is the empathy you bring, understanding in particular child abuse victims. And I feel like that's a perspective that would serve a judge well in criminal situations in trying to wrap one's head around the defendant's situation. So with that, I have no further questions. Thank you, Mr. Chairman.
Thank you, sir. Counselor Duff.
Thank you. To pick up on Councilor DiPaolo's, a little bit of what you two just spoke about. You've made in your answer to me a great assumption that the defense attorneys know a lot of these kids are poor. They have CPCS attorneys, they have court-appointed attorneys who are overworked and grossly underpaid. They don't know their attorneys. Their attorneys don't know.
Well,
I mean, that's a huge, huge assumption to me.
no question about that, but they know them better than I do. And they're the ones that are representing them for sentencing. And part of that representation, being a zealot advocate, is they should be doing their best for their clients. And maybe they're going to have to take a little bit longer to get to know them a little bit better so they can present a legitimate sentencing argument to help me or whoever the judge is to be able to make those decisions based on the appropriate factors. I mean, that's what a defense attorney does. That's what they're supposed to be doing.
How much criminal defense have you done?
How much criminal defense? Well,
Have you done?
I've not appeared as a criminal defense attorney, but with the decisions I've had to make in terms of charging decisions, in terms of who we're going to file sexually dangerous person cases on, I have to think like a defense attorney when I make those decisions. Correct.
You've never been a defendant, a lawyer defending somebody in court. You're always prosecuting.
Criminally, we're talking about, right?
Okay.
Because I did defend the county.
All right, that's it. Thank you.
Well, thank you very much. Just quick. My turn, I guess. And I don't have a lot. I do want to, and I've been talking about this for a few weeks, but first of all, I want to thank you for your service to the Commonwealth. You have a remarkable career. Some of your writings and the case you've been involved with, I haven't seen the likes of it, and I've been here for 7 years, but the amount of real serious cases that you've tried is just astounding to me. I think you're going to be a great judge. I appreciate you doing all the sex offender cases. As a cop for 30 years, I did a lot of SANE interviews, and the worst part of the job, but someone needs to do it, so I applaud you for that. You brought up Gosnold, a little sore spot for me. It's one of the cities and towns that I lost last year when I had an opponent. Someone got 3 votes and I got 2. And my former police officer was the police chief. He's the harbor master and everything else out there. So I have to get him working a little harder for me out there. I think I told you earlier, Ted called me, Teddy Zambellis, and threatened me that if I don't vote for you, he'll ruin my sandwich the next time. I go to Tugboat Ted's down the Cape. So he's a big fan, and I appreciate his input as always. I appreciate the crowd you brought here today. Councilor Hurley, I spoke with last night. She extended her sorrow that she couldn't be here. She has a physical problem going on right now, but she said she spoke to you and you have her support next week as well. So I'm pretty good at counting, and so far I think I counted to 8. So I think it's going to be a unanimous vote next week from what I hear, and it's not often all the councilors pledge like they did today. So that says a lot about you. There is one thing that bothers me. It's one of my pet peeves, and this is one of the things of the job that we can do is use this sometimes to make good things happen or address problems in the court system. And a few weeks ago, I brought up that a person that I know got thrown out of the court officer academy. And since I brought that up at the Governor's Council and Ted Daniel at Fox 25 did an investigative report on it, my phone rings off the hook every other day about people that have been assaulted, people that have been demeaned, berated. And in your experience, have you heard any of those complaints down the Cape about how court officers are treated at the academy over the last 5 years or so?
I have to be honest with you, this is the first that I've heard there's a court officers academy. I didn't even know there was a court officers academy.
So there's an 8-week academy. They tell you you can leave after 2 weeks, but you have to live there the first 2. In reality, you have to live there all 8. Let me just read you a couple things that I just got an email from a court officer, and let me ask you if you think this is part of it. So they do this at an Air Force base, which is federal. So my understanding is now the Massachusetts State Police don't have jurisdiction. So if you get assaulted or you get raped or anything happens, Massachusetts cannot bring charges. You have to go to the federal system. And that's what I'm learning now. And they changed that about 5 years ago. But this is a lady who told me that she had attended other academies, countless trainings, seminars, etc. It was a complete shock the way I was treated. I am not naive to say the start of any public safety job should be somewhat stressful and chaotic. However, it should always be teachable moments. When I was informed that an investigation is being launched into the training staff, I was relieved. It's long overdue. The training staff is degrading, insulting, and unprofessional. The curriculum does not teach skills. Rather, it breeds a hostile work environment, encourages sexual harassment, promotes retaliatory interaction between recruits, and causes unnecessary physical injury at the hands of the instructors. The bag drill on day 1 was embarrassing to say the least. Being told to hold up 10 pairs of underwear for 80 people to see was unnecessary. Producing ditty bags of toiletries, which had to be presented in clear bags, needed to be inspected for contraband, they say. Now that I think of it, I find it odd why a male drill instructor had to inspect my feminine hygiene products. It was humiliating, but not the worst of things to occur in the grand scheme of things. We had a lot of female recruits, not for failing or poor physical performance, but because they were new mothers and having a difficult time being away from their babies. When they showed emotion while making their evening phone calls, they were ridiculed by female instructors for being weak. Imagine one woman telling another woman she's weak because her maternal instincts were yearning to see and talk to a child. And I'm not going to read this whole thing, but I'm going to just paraphrase a couple things. Fridays, we would line up at our vehicles. One Friday, prior to being dismissed, the instructional staff demanded that we drink from our issued canteens on our belt. We continued to drink for 15 minutes. Finally, having been satisfied that we drank enough of our canteens, we were instructed to dump the rest of the water on our heads. Anyone who did not drain them completely drove home wet, then dumping their canteens onto themselves. I had a 2-hour ride. I had to stop twice at a rest area, completely unnecessary. One particular instructor, and I'm going to read his name publicly because I've heard that this Nick DeAngelis, the head drill instructor, slapped someone across the face this last academy, and I know that person well, and I spoke to other recruits who will testify that it happened. He would lead the instructor for defensive tactics and would regularly toss people to the ground, kick their legs out from under them, and warn them your head should be on a swivel. He manipulated joints excessively. He would grab recruits and go 110%. Many recruits complained about wrist and ankle sprains after being tormented. The OC day. Now, I heard about this OC day where they spray you with pepper spray. And the last class, I can tell you that I understand about 30% of the